On the topic touched earlier by our majority leader, Mr. President, this is the issue of whether the impeachment complaint transmitted by the House of Representatives to the Senate last February 5, 2025 can cross over to the Senate of the 20th Congress. Well, Mr. President and my dear colleagues, doubts have been publicly expressed by certain personalities whether the trial of the impeachment complaint against the Vice President can continue or cross over into the 20th Congress. I wish to share and put on the record some of my thoughts on this particular issue. Article 11, Section 3, Paragraph 6 of the Philippine Constitution provides that, and I quote, "The Senate shall have the sole power to try and decide all cases of impeachment." Hence, this provision makes the Senate not just an impeachment court, but the impeachment court. An impeachment proceeding is sui generis, that is, unique or a class of its own. In Republic versus Sereno, it is described as a proceeding exercised by the legislative as representatives of the sovereign to vindicate the breach of the trust reposed by the people in the hands of the public officer by determining the public officer's fitness to stay in office. While the form, procedure, and substantive arguments in impeachments remind us of a court trial, it also has the characteristics of a political process. The decision-making process in impeachment is not governed by any fixed or binding standard of proof, allowing for broad discretion on the part of the members of the impeachment court when they make their final decision on the case. The decision makers or the members of the impeachment court can use any standard of proof they want, and this choice will not be subject to any review by any court except the court of public opinion, which is not technically a court. This fact gives the impeachment proceedings its political character. Hence, to better understand these sui generis impeachment proceedings, we need to look for analogies using well-known principles and practices in other systems which are applicable to impeachment proceedings. As to the question of whether the impeachment trial conducted by the Senate in the 19th Congress or the impeachment complaint entertained by the Senate in the 19th Congress can cross over and continue into the 20th Congress, there is no provision in the 1987 Constitution or in the Senate Rules of Procedure on impeachment trials that expressly prohibits this. On the contrary, the Senate Rules on Impeachment support the position that the impeachment trial shall continue until final judgment, even if it is necessary to continue into the next Congress. Let me read the rules. Rule number 3. Upon presentation of the articles to the Senate shall specify the date and time for the consideration of such articles. Unless the Senate provides otherwise, it shall continue in session from day to day, except Saturdays, Sundays, and non-working holidays, until final judgment shall be rendered, and so much longer as may in its judgment be necessary. There is a contrary opinion that the rules of the Senate which mandate that all pending matters and proceedings shall terminate upon the expiration of one Congress should take precedence over the cited rules on impeachment, which state that the trial shall continue until final judgment. The justification for the precedence given to the rules of the Senate is that the latter were passed by virtue of the power granted by the Constitution to the Senate to promulgate its rules. That is found in Article 6, Section 16, Paragraph 3, which provides each House may determine the rules of its proceedings. However, the Senate rules on impeachment were also passed by virtue of the power granted by the same Constitution to the Senate to promulgate its rules on impeachment. So let us all look at Article 11, Section 3, Paragraph 8, which provides the Congress shall promulgate its rules on impeachment to effectively carry out the purpose of this section. In fact, there should be no conflict between the two rules because the rules of the Senate apply to legislative proceedings of the Senate, while the rules on impeachment apply to cases of impeachment. On this issue, the Supreme Court in the case of Pimentel Jr. versus Joint Committee of Congress ruled that the legislative functions of the 12th Congress may have come to a close upon the final adjournment of its regular sessions on June 11, 2004. But this does not affect its non-legislative functions. Conducting impeachment trials is most definitely not a legislative function. In fact, the section in the Constitution which speaks of impeachment is found in Article 11 under the title Accountability of Public Officers, and not under Article 6, which is titled the Legislative Department. The conduct of impeachment trials, therefore, should not be affected by the final adjournment of the legislative session. Furthermore, we can use the analogy of the court system. Under the 1987 Constitution, the Senate is the impeachment court. The Senate in impeachment cases is more like a judicial body than a legislative one. Just like a court, the workload, caseload, or docket of the Senate as the impeachment court will not and should not be affected by a change in membership. We can see this principle in action in all our courts and electoral tribunals, where their case dockets do not change and are not reduced or reset to zero whenever there are changes in the court's membership. Likewise, it is well settled that jurisdiction once acquired is not lost but continues until the case is terminated, and hopefully terminated to its logical end. Hence, it is my humble opinion that the trial of the current impeachment case, now pending before the Senate of the 19th Congress, can cross over or continue from the 19th Congress to the 20th Congress. The impeachment docket of the Senate Impeachment Court continues and remains to be the same. So thank you very much, Mr. President, my dear colleagues, for your time and attention.
Thank you, Senator Koko Pimentel, our distinguished Minority Floor Leader.
Although that was only a manifestation, I am willing to entertain questions. Should there be any questions, Mr. President?
Just two quick questions with the permission of this body.
With the permission of the Honorable Pimentel, the gentleman may proceed.
Mr. President, kanina po narinig ko yung historical antecedents ng binanggit, Your Honor, Senator Pimentel. Would the good gentleman agree that the reason why the position of constitutionalists, textualists for that matter, on this issue is that the Constitution is silent as to the word carry over, crossover, continue. Meron po ba nakalagay sa Constitution, sa Saligang Batas ng Pilipinas, 1935, 1973, 1987 na carry over?
Mr. President, I will respond directly to the question. Wala pong nakasulat doon that it shall carry over, pero binanggit ko sa aking manifestation, wala talaga rin nakasulat doon that it cannot cross over. So in effect, let us say textually, both positions are not even mentioned or entertained in the Constitution.
Mr. President, sang-ayon po kaya ang ating ginagalang na minority leader na kaya dahil walang carry over notion ay dahil malaki po ang pagkakaiba. There's a big difference between the 1987 Constitution and the 1935 Constitution, which was patterned after the United States Constitution. And I would like to have this placed on the records, Mr. President. Sa US Constitution, 100 po ang senador at nag-i-eleksyon po every 2 years ng 33 senators. Ang naiiwan pong senador sa Estados Unidos pag nag-i-eleksyon ay 67. Because 67 plus 33 is 100. 67 is sufficient to comply with the provision of the US Constitution to convict in an impeachment case. Dahil 2/3 po yon ay 66. May sobra pang isa. Sa atin pong saligang batas noong 1935, kung inyo pong susuriin, ang atin pong senador na bumubuo rin ng impeachment court ay 24. Subalit, Mr. President, in the 1935 Constitution, ang eleksyon po natin ay 8, 8, 8. Tuwing mag-i-eleksyon ng senador, ang i-elect na senador kasama sa mga kongresista ay 8 senador lamang. Ang may iwan po ay 16. And 16 is 2/3. Enough to have a quorum as well as to convict or to acquit. In our present constitutional scheme, 1987 Constitution, we also have 24 senators, but we conduct elections every 3 years for 12 senators. Meaning to say, Mr. President, yung may iwang kalahati na 12 is not sufficient to constitute a quorum, dahil 12 dapat 13, much more convict. Because to convict, you need 16 senators, Mr. President. Is it now the proposition of the good minority leader that the constitutional spirit as enshrined in the 1935 Constitution, the same as the spirit prevailing, although it is not as admitted by the good minority leader, textually enshrined, the same as the 1935? Ibig sabihin po ba yung 12 ay may quorum, yung 12 ay pwedeng maging 2/3 to allow your notion that we can carry over at yung sikat nga yung salita, maitawid? Tama po ba yun, Mr. President?
Ako, Mr. President, yung 2/3 kasi is actually that was probably just the decision of the framers of the Constitution. They could have made it 1+1. They could have made it 3/4. So it's maybe by accident that 2/3 is equal to 8 + 8 is 16 is 2/3, so 24. But I do not think that was really the point, Mr. President. But at any rate, we have to live with the 1987 Constitution. So we look at the 1987 Constitution. And looking at the 1987 Constitution, the Senate is the impeachment court Not because it is the Senate created under Article 6, because it was recognized to be the court under Article 11. The framers could have chosen another body to be the court. That is theoretically possible. But it chose the Senate, not as a legislative body, but as a part of Congress, but not as a legislative body. So, yun po yung aking pagkaintindi. We have to live with the 1987 Constitution. We copied generally the idea siguro sa United States, but let's not be so beholden to their practices and rulings kasi iba na rin po, iba talaga ang sitwasyon natin. And I think textually speaking, my position is supported that although we keep on saying Senate, 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 but this is not Senate as the other half of Congress, but this is the Senate chosen under Article 11 to be the impeachment court. So iba po ito. And then may paragraph 8 doon, sinabi, Congress shall also issue the rules to give life to the accountability of public officers. So, and we have done that. So, kaya ang aking stand actually is the Senate as an institution is the impeachment court. So the member judges can change, but just like as a division of the Supreme Court, division of the Sandigan Bayan and the CA, if they change their members, yung docket nila or caseload nila, tuloy pa rin. They have to decide the cases and bring the cases to their logical conclusion. So that is my simplified position, Mr. President.
So one last question, Mr. President, if the good gentleman would accede. Ang ibig sabihin po nito, Mr. President, is that the Senate now, under the 19th Congress, is empowered, is authorized to confer a jurisdiction to another Senate, which would be forthcoming, the Senate of the 20th Congress. So, allowed po ba tayo under the Constitution to transfer pending business, or should it follow likewise, using your logic, the traditional norm of having it refiled and reset starting from zero? Similar to the bills.
Yes, yun na nga.
So, ibig ko sabihin, Mr. President, what would prevent the 19th Congress from passing on the impeachment case, not just to the 20th Congress, but to the 21st Congress? And I implore the good minority leader that all the provisions mentioned a while ago, which are correct, should likewise be read together with the constitutional provision that there should be only one impeachment case filed per year against the same respondent, Mr. President.
Alam nyo ba, Mr. President, na yung rule na yung legislative workload natin ay magre-reset pag may bagong kongreso? Alam nyo ba na wala sa Constitution yun? Nasa rules natin yun. Ang rules natin, promulgated natin because of the power given to us by the Constitution. But the Constitution does not specify that. Actually, we could have written na yung pumasa na ng third reading, itrato natin na third reading na rin. We could do that, but we did not do it. So policy lang po yun na reset natin as far as legislative workload is concerned. Pagdating naman sa impeachment judicial workload of the Senate as an impeachment court, I propose, or I give the interpretation that the caseload remains. Ang nagbago lang are the member judges. Just like, I think we can easily envision sa Supreme Court, nagbabago, divisions ng CA, divisions ng Sandigan Bayan, but the caseload remains. So I think we can mentally separate the two kasi Article 6 yung legislative workload, Article 11 yung impeachment workload. So that's that would be my response, Mr. President.
But Mr. President, would not that prevent the other part of the two-step process? Two-step process because filed by the lower house, prosecutors,
Yeah.
received by the Senate, the trial jurors, the trial judges. Would not that prevent the other part of the two-leg process from initiating another complaint? Because there is now a case pending, which you say should be continuing.
If the majority leader will allow me not to respond, but
Yes, because
his question is very loaded and provides the hint of what can happen in the future.
Mr. President, I've taken too much time of this body. I would relish interpolating the good minority leader even for 5 hours on this topic alone. But again, Mr. President, siguro mahabang-mahaba na po ito. I stick again to my previous manifestation that if we will not be able to conclude whether acquittal or conviction, the present impeachment case against Vice President Sara Duterte before the lapse of the 19th Congress, the same is functionally dismissed or deemed de facto dismissed, Mr. President. Yun lamang po, Mr. President, at ako po ay nagpapasalamat sa ating minority leader.
Thank you, Senator Tolentino. Briefly, Senator Pimentel.
Mr. President, while I still have the floor, can I request for some information from the Senate President, especially regarding the impeachment calendar that
The
is
gentleman may proceed.
because you issued the first impeachment calendar was issued by the Senate President when we were already on break. I mean, Mr. President, tama po yun, di ba?
That is correct.
So, Mr. President, may we know when His Honor issued the first legislative calendar, impeachment calendar, which fixed June 2 as the time for receiving the House prosecutors, may we know the basis of the authority of the Senate President when he issued the first impeachment calendar, Mr. President?
Article 1 of the impeachment rules, which says that the Senate President can set the date for the presentation of the articles of impeachment. Mention was made specifically of the Senate President. And also we were on recess. So the Senate President at that time, Your Honor, issued a suggested calendar of activities. I was very clear when I stated that. Subject to plenary approval when we resume, because you were already on recess at that time. The second notice sent by this representation was made also while we were on recess. And I also stated that it was subject to plenary approval and or reversal as the case may be, given the load that we need to take up after the LEDAC meeting.
So, yes, Mr. President, I noticed that no one from the majority was complaining about the original or initial impeachment calendar issued by the Senate President. So we were all looking forward to the date where there should be some action on the impeachment, which is
Yes.
June 2.
Supposedly, yes.
Yes, supposed to be. Kaninang 4 o'clock yung the prosecutors from the House of Representatives should have appeared before us to read the articles of impeachment. But then this was changed. So from June 2, changed by the Senate President also, now
June 11.
it's June 11 at 4 p.m. So if the authority used to issue the original calendar was based on the fact that we were on break, now that we are not on break, could not have the Senate President waited for 3 p.m. and then we discussed moving the June 2 4 p.m. to June 11 4 p.m.?
Because, Your Honor, notice had to be given to the House with respect to the proposed change in schedule. And we could not decide on moving it after the House members have already are already here
Yeah.
in the Senate. That was the reason behind it.
That was His Honor's judgment call, Mr. President.
Yes, Mr. President. Yes, Your Honor.
Just on another matter, Mr. President, yung appearance ba ng House prosecutors ay nasa Senate impeachment rules or you just took this from American practice, Mr. President?
It is not in the rules. That was lifted from American practice because what was done before was that the majority leader,
Yes.
the Senate majority leader, was the one that read the articles of impeachment that was referred to the Committee on Rules that triggered the convening of the impeachment court. When we researched on it, we thought it was more proper, given that we should have no part in it, in the impeachment trial, in the prosecution of the impeachment case, that the prosecutors should themselves read the articles of impeachment, as is the practice in the United States, where we lifted most of our impeachment rules.
So it's an innovation. But although, had we done it, hindi naman, I don't think it would be fatal or make the proceedings infirm. So it's just not, to use the term of the majority leader, textually required under the existing Senate impeachment rules. Hindi pa ba?
No, what was required by our rules, if at all, was the referral of the impeachment complaint in plenary. Because mere filing with the Secretary General does not often by itself operate as the receipt by the Senate in plenary, given that, as with any communication, it has to be referred in plenary, officially by the Senate as a body.
Mr. President,
Sige, Mr. President.
Mr. President, with the permission,
Senator Tolentino is recognized.
Minority
What is
Leader.
your pleasure, sir?
would the loaded question of the good minority leader, if decoded, would mean that should the presentment be made before the Senate sitting as a plenary, or should the presentment be made before the Senate constituted as an impeachment court? Baka yun po yung tanong nyo.
But it was, it was the Senate President to research on American practice. How do they do? How do they do it in the United
In
States?
plenary, Your Honors, not as an impeachment court, because again, mere receipt by the SecGen does not operationalize or start the process of impeachment. Any communication, and that is a communication from the House, must be referred by plenary to the appropriate committee for proper action. That in turn will now trigger, if at all, the convening of the impeachment court, where the regular processes would now be followed, such as the issuance of summons, etc., etc.
May we know the rule, Mr. President, that it
I'm
should
sorry?
be? May we know what the specific rule is? That in the rules, or is that by practice or costumbre? Tingnan niyo ano rule.
Under Rule 3, Paragraph 2, upon presentation of the articles to the Senate shall specify the date and time for the consideration of the articles.
Yes, but
So the articles need to be presented to the Senate.
yes, but so your Honor is reading our Senate impeachment rules.
Yes.
Correct. So when we use the Senate in the Senate impeachment rules, we're talking about, we could be talking about the Senate as the impeachment court. Because
We
it's the
have-
Senate.
And by virtue of the procedure in Articles 1 to 3, we have not yet convened the court, Your Honor. For example, succeeding rules in our impeachment rules, 4 onwards, would pertain to the Senate already as an impeachment court, because that is already the trial proper, beginning with the issuance of summons.
Mr. President, the second sentence already contradicts His Honor, because it says, second sentence of that second paragraph of Rule 3, unless the Senate provides otherwise, it shall continue in session from day to day. Session na yan as court. Kasi until final judgment eh. Yun na yun eh. So, the use of, when we use Senate in the Senate impeachment rules, we refer to the Senate as the court.
Mr. President,
According to the Secretariat, Your Honor, the dividing line is when we take our oath as senator judges and convene as such. Because we will be wearing two hats, Your Honor. As senators, performing our legislative and legislative function, and as members of the impeachment court, performing our sui generis function. And these are two distinct, if at all, hats and functions that we would be performing. That's why we have to adjourn session and convene as an impeachment court, and vice versa if we want to revert back as a plenary.
Well, Mr. President, ano na lang for so as to
Mr. President.
our staff can revisit. Ito yung sentence natin, ano? Second paragraph of Rule 3 of the Senate impeachment rules. Upon presentation of the articles to the Senate shall specify the date and time for the consideration of such articles. Unless the Senate provides otherwise, it shall continue in session from day to day until final judgment shall be rendered, and so much longer as may in its judgment be necessary. So, are we using the word Senate in one paragraph in two concepts? One as Senate legislative body and the other as the court?
I believe so, Mr.
Correct.
President, Your Honor. But again,
So,
since these manifestations, also the manifestation made by our distinguished majority floor leader himself earlier, after these manifestations are made, these matters and these statements will be referred to the Committee on Rules for them to look into it. We have time, Mr. President, Your Honor, to resolve this matter in due course in the next couple of days.
Mr. President,
Yes.
if I can direct this question to the good minority leader. The Senate, even if not acting as an impeachment court, pwede po bang tumanggap ng mga non-members of this chamber to speak or make a presentation, a presentment? Di po ba naaalala natin ng mga nakaraang panahon, pumupunta rito yung President of Vietnam, if I'm not mistaken. Distinguished guests of this chamber are allowed to speak, not just honored. Ganun po ba yung sinasabi nyo? Na baka are the members of the House, though constituted as panel of prosecutors, can they enter the Senate, this chamber, constituted as a plenary or as an impeachment court or both? Pag pinapayagan ng Senado. Baka ganun po siguro ang gustong
Okay.
malaman ng ating minority
Oo.
leader.
Just for the information of the majority leader, yung appearance of the House prosecutors before the Senate kanina sanang 4 o'clock, June 2, appeared in the impeachment calendar prepared by the Senate President. Hindi ako may idea nun. At saka, when we read our Senate impeachment rules, wala din dun yun.
So they will
That's
be
why-
appearing
that's why-
before an impeachment court.
That's,
Yung po-
that's why this is the request for information. Now, what did the Senate President have in mind when he scheduled this for June 2? And I think it's clearly, since 4 p.m. siya, it's clearly an appearance before Senate,
Yes.
the plenary session of the Senate.
Again, the
Yes.
basis is U.S. practice. That is how they do it in the United States, where we lifted portions of our own impeachment rules. That's where it came from. Practice and precedents in the United States.
And per our legislative rules, we can waive the rules so that we
can
allow
suspend the
non-members
rules to allow
speak.
it.
Di ba dito, recently, nagsalita rin si former UN Secretary
Korean,
General.
South Korean.
Huh?
The South Korean.
Yes, that's UN Secretary General. So
That can be
so we
allowed.
can do it. Yes.
Again, that can be allowed. Again, plenary action is necessary, and the plenary will decide on this matter.
So just a few more requests for information, Mr. President. So, Mr. President, His Honor, around 4 days ago, sent notice that the June 2, 4 p.m. appearance of the House panel of prosecutors will be moved to June 11, 4 p.m.
Yes.
So, okay. Now, what is now the calendar that His Honor has in mind. Kasi dati meron kang June 2, 4 p.m. appearance, then June 3, morning, we convene the Senate as an impeachment court. So where is that? Where is this convening now? Where is it now when you move the appearance to June 11?
Sabay na po, because by that time, by June 11, wala na rin po tayong hinahabol na kailangan i-second or i-approve kung meron man, ratification na lamang ng mga bicameral conference committee reports. And we will be doing both at the same time. If at all, the reading of the articles of impeachment, the referral to the Committee on Rules, the convening of the impeachment court, if at all again, the oath of the senator judges, if at all again, all that we can do as an impeachment court would be to issue summons.
Yes. Oh.
Requiring the respondent to answer within 10 days.
But were we sent notices na ganun ang mangyayari?
I'm sorry?
Were the senators sent notices or informed that after the appearance of the House panel of prosecutors, there's a possibility that we will convene as a court? Para ready kami.
Wala pa.
Wala pa nga po. Kaya wala kita po yung June 11.
Wala pa naman talaga eh. Kasi nung pinadala yung notice na yun, it was addressed, if you notice, it was addressed to the House that they will be presenting the articles of impeachment on that date. The notice insofar as the impeachment court itself is concerned, these discussions would be very helpful, Your Honor, because this will be part of how the Senate as a body will be deciding on what to do after the articles of impeachment shall have been read and presented before the body.
Yes, but Mr. President, nung in-issue kasi ninyo yung impeachment calendar last February, at least you were that detailed na sinabi nyo na po yung convening of the impeachment court. Ngayon sana po, nung i-defer si June to appearance, sana pati po yung convening as an impeachment court, nasabi na rin when that is para may idea.
Well, thank you for the opportunity to clarify. Since that is our last day, this representation has no intentions of actually convening the court, if at all, on another date other than the 11th, unless the Senate as an impeachment court provides otherwise. So we will be convening on that date, barring any unforeseen circumstances, barring any procedural motions that will be made, and will be settled by the plenary at that time.
Well, Mr. President, it was just, ito lang for the consumption of our staff and secretariat. It was just pointed out to me that the rule that we mentioned earlier, second paragraph of Rule 3, yung first paragraph pala, it provides that nakapag-oath na. Nakapag-oath na ang member. So if that is now the dividing line, we have crossed the line. So Senate na po ito as a court. So tingnan na lang po muli, Mr. President.
Mr. President, Your Honor, the first paragraph refers to consideration of the articles of impeachment. The second paragraph, we were not part of the Senate that wrote these rules. The first paragraph, it mentions the word consideration. The second paragraph mentions the word presentation. In terms of time, presentation should come first before consideration, although as it appears in our rules, consideration was mentioned first in the first paragraph and before presentation in the second paragraph. But in terms of order, Your Honor, presentation should logically come first before consideration of the articles of impeachment. And then there is nothing to consider unless presented.
And then in the next breath, it talks about the trial na.
Yes, again, we had no part in writing these rules.
Okay,
I
so
would not want to critique it as well because during those times, perhaps this was apt and sufficient.
So Mr. President, maybe now kasi ang media nagtatatanong sa akin, pinapa-speculate pa ako na just for the record, what is now the reason that His Honor has taken the initiative to reset the June 2 2025 4 p.m. appearance of the panel of prosecutors before the Senate plenary to June 11 4 p.m. What's the main reason
addressed to Speaker Martin, copy furnished to all of the senators as well as Vice President Sara Duterte. Given the meeting we had at LEDAC with His Honor's presence, several bills needed to be approved and taken up before we finally could finish and wind up the 19th Congress. Meaning to say some bills need to be approved on second reading within the week today so that we can do third reading next week. Some bills have to be approved on third reading today and within this week so that bicameral conference committees can finalize and iron out the disagreeing provisions between the Senate and House versions so that we would still have time next week to either ratify these bicameral conference committee reports or still do third reading in compliance with the constitutional requirement of 3 readings on 3 separate days, at least 3 days after it's approved on second reading.
So, sige, last question na lang, Mr.
Apa.
President. Per our rules or practice, how would we now react to the receipt of the articles of impeachment last February 5, 2025? How should the Senate as a legislative body in plenary session react to that receipt?
In line with Article 1 of our impeachment rules, which makes mention of the authority and responsibility of the President of the Senate. That is why I set the schedule for the articles to be read in plenary, which in turn would trigger, if at all, the creation of the impeachment court. Which, if at all, would now proceed with the issuance of summons for the respondent or defendant.
Would not the impeachment complaint received last February 5, 2025 be included in the reference of business?
Reference of business or hindi? Calendar.
Ano ito? Ito ba ay? Ito ba ay first step?
It will be included in the reference of business, yes. Supposedly today, kung natuloy tayo today, but on June 11, so that it can be included in the agenda for that particular day.
That's my point, Mr. President. Kung i-reference of business, why are we not doing it today? Anong damage kung gawin natin today?
Pwede rin naman. Hindi pa tayo
Yes.
nagbabasa ng reference
Yes,
of
yun
business.
na nga. Sure.
Pero wala no?
Are we doing it today? Kasi February 5 pa yun. That's why I'm mentioning the date that it was received, February 5. So can we include it in the reference of business today? Kasi parang mas normal eh. Mas normal yun eh. Kung
We will look into it, Your Honor. I tend to agree with this Honor's position.
It's
We
just
will
no-
take it up with the Secretary.
It's just normal, Mr.
Yes,
President.
yes.
Received last February 5, we're reporting out today. Okay?
Off the record, they explained the reason behind it. But I tend to agree with Your Honor, and I'll ask the Secretary to consider it. Because in the past, as they said, it was the majority leader who read it and not the prosecutors, supposedly. So it was included in the reference of business, referred to the Rules Committee, and the majority leader was the one who reported it out, quote unquote. But now, given that it's the prosecutors that will read the articles of impeachment, again, following U.S. practice and precedent, the Secretary thought it best that it'll be included in the agenda on that day because there is no referral to the Committee on Rules. But again, we will look into it and we will take the suggestion of the gentleman in light of the points he raised in connection with that.
Because I believe there should have been also a letter accompanying the impeachment complaint. There must have been a cover letter from the House. So, parang ganon. So we can...
Only by the section, not by the Speaker nor any member of the House.
Yes. But is a letter from the SecGen also a communication from the House?
It was a covering letter only.
Yeah. So I think this is just an opinion.
I tend to agree, Your Honor.
It's more natural that we report out if something happened last February 5, late evening of late in the session on February 5. Something happened, we report it out in the So it's more natural if we report it out immediately, Mr. President. So
I tend to agree,
that's
Your
all,
Honor.
that's
Again,
my point, Mr.
I
President.
will take it up with the committee secretary.
So with that, Mr. President, I thank you for answering my questions.
Thank you, Your Honor.
I just wanted to request some information. Thank you, Mr.
Thank you, Your Honor. What is the pleasure of the Honorable Antiveros?
Salamat, Tabi, Mr. President. Gusto kong magdagdag ng point dun sa binanggit pareho ng majority leader, ng minority leader, at pati ng Senate President, yung references sa US practice and precedent. Kaugnay nung isa sa mga issue na pinag-usapan dito sa floor, kung pwede ba o dapat bang mag-carry over yung impeachment process mula sa 19th Congress hanggang sa 20th Congress. And I would just like to put this on the record, Mr. President. Galing po ito sa isang piyesa authored ni UP Professor Paulo Tamase, nag-appear po sa June 2025 issue ng Philippine Law Journal. Sabi po dito, Emerging Issues in Impeachment, page 19 dun sa journal, allowing impeachment to cross over Congresses is consistent with American practice. Following the practice of the United Kingdom, Thomas Jefferson's Manual of Parliamentary Practice states that an, quote, impeachment is not discontinued by the dissolution of Parliament, but may be resumed by the new Parliament, close quote. The US Congress na binanggit ng majority leader, ng minority leader at ng Senate President, the US Congress has observed this for over 200 years, from the 1803 impeachment of Judge John Pickering to that of Judge Porteus in 2009. In Congress, impeachment proceedings are not discontinued by a recess. The following impeachment proceedings extended from one Congress to the next. 5 pong halimbawa, Mr. President, sa article na ito. Babangkitin ko lang yung pang-apat kasi yun pamilyar sa ating mga Pilipino. 4. The impeachment of President Clinton was presented to the Senate after the Senate had adjourned sine die. After, Mr. President, the Senate had adjourned sine die for the 105th Congress, and the Senate conducted the trial in the 106th Congress, Mr. President. So, for the record lamang po, dahil very, very pertinent sa binanggit ng majority leader, ng minority leader, at pati ng Senate President na following US practice and precedent. And with one very recent concrete example po dun sa impeachment ni US President Clinton. So I hope that we can consider this in our own decision-making, Mr. President, even after the rescheduled presentation by the House prosecutors to the Senate as an impeachment court on 11th June. Salamat, Tabi, Mr. President.
Duly noted and entered into the records. Majority Floor Leader.
Just to reiterate again, yung nabanggit ko po kanina nga, magkaiba yung sa Philippine Senate at US Senate kasi ang naiiwan sa US Senate tuwing mag-ieleksyon ay 67 senators, enough to constitute a quorum out of 100 senators and enough to convict or acquit. Sa atin po, 12 lang, not enough to have a quorum of 13, more so a number of 16 to convict or acquit. But be that as it may, Mr. President, we have all the discussions done, and I think this would really be part not just of the discussions that whatever case would be elevated to the Supreme Court would eventually be decided in the near term. Mr. President, I seek a minute suspension, Mr. President.